Donald, you have 10 minutes.
Chairman, when my client was served with the petitions last week, she gave me copies of the petitions. I immediately wrote to the clerk of the assembly to confirm those petitions. The one by the Republican Liberty Party is 22 pages. The one by Reverend Dumbi is 31 pages. The one by Geoffrey Langat is 5 pages. And the last one by Award Steve Jerry is 6 pages. Those pages are very important, Mr. Chairman. Once the whole House of Parliament or a committee basically constitutes into an impeachment proceedings committee, it becomes a court of law. And the basic principle of law is parties are bound by the pleadings. So the 4 petitioners are bound by the pages I've referred to. Mr. Chairman, in the South African case of the removal of the Speaker Dilile, which has been referred by by our court so many times, and also the decision of our constitutional court in which they quashed the decision of the JSC. Both decisions of South Africa and our constitutional court arrived at the same basic decision that once you're doing impeachment proceedings, you are bound by basically our laws. And the High Court and the constitutional courts have a right to supervise what you're doing. In response to Mr. Chairman, in response to those 4 petitions, I filed the POs on all the 4 petitions. And I urge you to refer, when you retire, to all the grounds I've set out in my preliminary objections to the 4 petitions. Just in a summary, Mr. Chairman, the petition by the Republican Liberty Party, it's on behalf of the party, but it's signed by Mr. Just 1 minute, the signature of the person is purporting to be the chairman of the party is Zakaria Matayo. But Your Honor, Mr. Chairman, if you look at Section 16 of the Political Parties Act, a political party is a corporate body. There is no way a person purporting to be a chairman can sign a petition. There is no seal of the party. There is no confirmation or evidence that the party is set to pass a resolution for that Mr. Zakaria to file this petition. The other issue which cuts across all the petitions, Mr. Chairman, is the petitioners referred to so many articles of the Constitution and the articles of the IEBC Act, the Leadership and Integrity Act, and the Public Office Ethics Act. Such petitions, Mr. Chairman, are muddled, they're expansive, they're ambiguous, and they're superfluous. As I've said before, again, you're bound by the laws of this country. A respondent needs to be given a case that has clarity, that is specific, that he can be able to answer. There's no way you can answer such petitions which are basically they go from Article 1 to Article 255 of the Constitution. There's no way you can answer such a question. So, you can answer such a petition. The other issue, Mr. Chairman, is none of the petitions is supported by an affidavit. A petition of such nature cannot be a statement. It can't just be a petition. It has to be backed by an affidavit that deposed to every allegation of fact in the petition. None of them is available in all the 4 petitions. Your Honor, impeachment proceedings, are the highest kind of legal proceedings against any individual because basically it ends someone's career. And you cannot base a petition on statement that is not evidence in an affidavit. Your Honor, Mr. Chairman, there are 3 allegations against my client: serious violation of the Constitution, gross misconduct, and incompetence. There is no evidence whatsoever on those allegations against my client. Your Honor, the other issue is again, as I said, you're bound by our Fair Administrative Act and Chapter 5 of the Constitution. Where again, across the 4 petitions, you can see that they are coming from a political bias. And that's again an ingredient in our legal system. Where a petition is motivated by bias, then it's not sustainable. You can see basically they are coming from the same political side. Finally, I don't want to take it too much. If the clerk was magnanimous enough to send me all the 9 decisions of this parliament from 2013 until now, all the 9 of them, only one actually succeeded, went through, the JSC one. But still the High Court quashed it. So basically the history of this parliament, none of the impeachment proceedings has been concluded. And just to take you back in history, impeachment proceedings began in England in 14th century during the reign of King Richard II. It was basically intention of Parliament to rein in the king without annoying the king. But then in 1795, that was the last impeachment in England, and England ended impeachment proceedings. So there are no longer impeachment in England because they realized the futility of impeachment when there are alternative remedies, which Mr. Arwa has argued, against a public official. We took our legal system, our laws from England. England has moved away from impeachment because it's a waste of time, it's a political tool, it's not a legal tool. It was supposed to rein in public officers for being corrupt, for being incompetent, and for treason. And now we have legal systems that are developed that deal with such errant officers. We have the Public Officers Ethics Act, we have the Corruption Act, we have the Penal Code. So basically, again, as such, if you go through my objections, we have alternative remedies, and this parliament should no longer be taking its time in impeachment proceedings. And Mr. Chairman, finally, as the petitions are not they're not supported by any affidavit. They are gossip, hearsay, and to paraphrase our Supreme Court, it's hot air, and they should not be allowed. They should not be entertained. They cannot be allowed to bring additional evidence. What they have filed is complete. I urge Mr. Chairman and the committee, when you deliberate, you go through the petition, you strike them out. And finally, Chairman, I was just saying that because we didn't have enough time to argue our case, if we'll be able to submit the case law, because I have so much case law supporting all the issues I've raised in our objection, I can supply the committee with the case law, and then so that when you're deliberating, at least there is supporting law.
Thank you. But impeachment still remains part and parcel of our constitution. So it is not illegal.
It's not illegal, but I'm saying even in England, they moved away. It's not, but it's still in the law in England.
We
it's still in the law, but they stopped practicing
it.
it. Yeah,
but it's not, it's still part and parcel of the celebrated constitution.
It is in the law, and
right.
In England.
Thank you.
But they don't.
Thank you very much. Thank you. Apollo, you have how many minutes? Yours are